Your questions have us returning to the Supreme Court decision to allow Lorie Smith, a website designer in Colorado, to legally discriminate against some same-sex couples. So how did a hypothetical situation go all the way to the Supreme Court? And didn't the justices just rule on a similar case involving a baker in Colorado? Here's Marshall Zellinger.
Twice now, the United States Supreme Court has ruled on Colorado businesses seeking to discriminate. On Friday, the conservative justices ruled that Lorie Smith can legally tell same-sex couples she will not design their wedding websites. In 2018, the Supreme Court also ruled on a case involving Masterpiece Cake Shop and baker Jack Phillips not wanting to design a same-sex wedding cake.
The issue that people believe was addressed in the Masterpiece Cake Shop case was largely sidestepped by the Supreme Court.
Attorney Liz DeLay helped explain that the cake shop case did not really set a precedent. That ruling found that the Colorado Civil Rights Commission was hostile toward Phillips's religious beliefs. The ruling did not allow for businesses to blatantly discriminate.
I think it's very reasonable to be confused given the Masterpiece Cake Shop case.
Smith, who wanted to design wedding websites, preemptively went to court because she did not want Colorado's Anti-Discrimination Act to force her to design a wedding website for a same-sex couple against her religious beliefs. The courts took her case, even though she had not received and denied a request from a same-sex couple.
I do think there's a big question of what then is the injury.
Before the case was argued in front of the Supreme Court, Smith interviewed with the New York Times. Some of that audio was played on the Daily podcast earlier today.
Rather than wait to be punished, I decided to take a stand to protect my First Amendment rights. And I shouldn't have to be punished before I challenge an unjust law.
Essentially what the court found was that she had filed for an injunctive relief, which requires only proving that there be a credible threat that the state would seek action against her under the Colorado Anti-Discrimination Act should she create a website and then not offer those same services to same-sex couples.
Despite this ruling, Colorado's Anti-Discrimination Act is still a thing. If you're a public-facing business, meaning a business that takes money for services, your reason to discriminate against someone has to be more than, because I don't want to. If you have religious reasons, the courts have opened up the path to challenge over other creative services. Things like t-shirt design and tattoos were a couple examples that Liz DeLay gave me.
There have been a bunch of articles kind of in the last couple of days suggesting that some of the evidence in this case was fabricated. That at one point Lorie Smith said, this gay couple came to me for a website. This is what I'm worried about. Now the guy who supposedly was involved in that said, I'm a straight guy. I didn't ask you for a website.
Straight guy didn't do it.
Does it matter?
Well, this original complaint had no bearing of anybody asking, and she even admitted in that audio, why should I wait for me to bring it to the courts? So clearly no. The courts had every opportunity to say, your original complaint had no actual request of you to do this, so come back when you have that. So now that that path's been open, I want to give a political example. People collecting signatures to get on a ballot. What if you don't live in that district, but you don't want that person to qualify for the ballot? Can you live anywhere in the state and be like, hey, we should challenge some of those signatures, even though I have no standing to say so, because this case said you don't have to have standing to get involved? Someone's going to have to take that case.
The court had already decided that she had standing to have this issue examined before this supposed couple came along. All right, Marshall, thank you very much.